Hey guys, it's your humble host, or Kill if you prefer, so I'm back with an update on Save James. This time, it's a filing from Jeff Younger to strike Ann Georgelis's affidavit, which we reviewed last time. You can find the link at the end of this video or in the playlist. Anyway, let's look at it. And as you remember from Anne's affidavit, she claimed that Jeff was putting the boys in danger, that he was bringing about instability to their emotional well-being because he wanted to homeschool them. She tried to register them for school. The school had to unregister them because what Anne did was technically against the terms of joint custody, joint conservatorship. So, by the way, yeah, the joint custody is still not in play like it should be by now. Anyway, this is 12 pages. I'm going to do my best to try to hit the important stuff. All of it's important, but you know what I mean. So, to said honorable court comes now respondent Jeffrey Damian Younger, who files his motion to strike affidavit of Ann Georgelis, which is attached to Exhibit A to petitioner's first amended petition to modify parent-child relationship, which was filed herein July 30th, 2020, for the following reasons. Now, from what I've been told, about the motion to modify custody terms, this is what I've been told, because Anne filed for a motion to modify before even a year has passed, if she loses it, she has to pay all the attorney fees. This is what I've been told. Again, I have no legal backing, but I did talk with Jeff about this document earlier today. So, 1.1, petitioner filed her first amended motion to modify parent-child relationship and is trying to go about the roundabout way of getting sole conservatorship after being told no 2 to 3 times. On July 30th, 2020, seeking temporary orders modifying the designation of the person having the exclusive right to designate the primary residence of the minor children of the parties, and that was filed well within 1 year after January 29th, 2020, the date of the order sought to be modified. So, yeah. Jeffrey Damon Younger filed a motion to deny relief pursuant to Code 156.102C of the Texas Family Code, requesting that the court refuse to schedule a hearing and deny all of the relief requested by petitioner, and was pretty much requesting that Jeff pay attorney fees. Also, don't forget that Jessica Janisic, her lawyer, was demanding in the motion to modify that Jeff pay the court fees directly to her, not to mention she'd be the one enforcing the order instead of the judge. The balls, just the freaking balls of these people, man. Let's continue. Including petitioner's request to modify the designation of the person having the exclusive right to designate the primary residence of the minor children as sought in the First Amendment petition to modify. Neither the First Amendment petition to modify nor any attachments provide the court adequate facts to support any allegations that the children's present environment would endanger their physical health. In fact, it's just the opposite. It's why you guys keep trying to attack the page. It's why you guys squawk and scream every time new photos comes out, because it goes well against your narrative. Once again, and I'm going to point this out, it's why you didn't want journalists or internet bloggers, as you like to label me, near the kids. You didn't want them around Jeff's home. You didn't want them anywhere near the situation. And once again, it is why you tried to have me thrown in jail. Twice. So, because everything that has come out, anybody that has come to investigate the situation for themselves that has not drunk the rainbow Kool-Aid can see the exact same thing and see that all of Save James, the page, the website, Jess, all of the claims have been backed up to a T. Anyway, let's continue. I think about it. Significantly impair their emotional health development as required by 156.102B of the Texas Family Code. You would have to look that up. Actually, let me do that for you. Yes, I was looking into something earlier. Okay, here is 156.102. Again, I'm not a lawyer, so this is a quick Google search for me. Here's B. The affidavit must contain, along with supporting facts, at least one of the following allegations: that the child's present environment may endanger the child's physical health or significantly impair the child's emotional development, which there's no evidence for, by the way; that the person who has the exclusive right to designate the primary residence of the child is a person seeking or consenting to the modification, and the modification is in the best interest of the child. Let me read that again. That the person has the exclusive right to designate the primary residence of the child, which Anne does not have because it is 50-50 conservatorship. She can't even file the freaking motion according to this. If I'm reading this correctly, this is Texas Family Code. She can't even file the motion to modify because she is not sole conservator. She is joint. Right to exclusive, let's see, the person has the exclusive right, so she doesn't even have that. According to what I'm reading, I don't know if that alone would get the modification thrown out. I don't know, but that should, to a point, nullify it. Let's continue reading. That the person who has the exclusive right to designate the primary residence of the child has voluntarily relinquished the primary care position of the child for at least 6 months, and the modification is in the best interest of the child. So the exclusive right bearer or sole conservator has to relinquish their right, which nobody has or is not a sole conservator. There's two joints. The court shall deny the relief sought. Here we go. The court shall deny the relief sought and refuse to schedule a hearing for modification under this section unless the court determines on the basis of the affidavit that the facts adequate to support an allegation listed in subsection B are stated in the affidavit, which there's nothing, there's no evidence, there's no exhibits, there's nothing. If the court determines that the facts stated are adequate to support an allegation, the court shall set a time and place for the hearing. So, right now, according to everything I read in my Texas Family Code, Anne doesn't have jack. She shouldn't be allowed to file a motion for modify because she's not sole conservator. Holy cow! Okay, subsection B3 does not apply to a person who has the exclusive right to designate the primary residence of the child, which neither Anne nor Jeff have because that's part of the conservatorship. It's joint, once again, 50-50. That was established, by the way. And who has temporarily relinquished the primary care position of the child to another person during the conservator's military deployment, military mobilization. Okay, that has to do with military. Don't even need to bother with that. But so according to everything I read, because Anne is not the sole conservator, nor did the sole conservator give up their right freely, relinquish it, Anne doesn't have shit to base this modification off of. She technically, by Texas Family Code, doesn't even have a right to file the motion to modify. If I'm understanding correctly what I'm reading. Again, I'm not a lawyer, but it's right there. It's not freaking gibberish. You can freaking read it for yourselves. If there's more to that, please let me know. But according to that, Anne can't even file the motion to modify. Petitioner attached her affidavit to her first amended petition as Exhibit A, and in that affidavit attempts to justify the filing of her modification, which there is none according to Texas Family Code from what I just read to you guys, action within 1 year of the entry of the prior order. Let me keep an eye on the time here. An affidavit is required on these under these circumstances pursuant to 156.102B, which is going to be this one. Again, the affidavit must contain, along with the supporting facts, at least one of the following allegations. And he went through them, which none of them qualify. None of those requirements have been met. Oops, I lost my place. Here we go. Of the Texas Family Code, and the analysis for the code must be whether the affidavit is legally sufficient under 156.102C of the Texas Family Code. Since petitioner seeking temporary orders changing the designation of the person who has the exclusive right, which again, she's asking for sole conservatorship in a roundabout way this time, which she got told no to twice, 2 to 3 times already, to designate the primary residence of the children, she has to meet the legal burden imposed by 156.006 of the Texas Family Code. Oh, they quoted it here, so I don't have to Google it. Which reads in part as follows. B. While in suit for modification is pending, the court may not render a temporary order that has the effect of creating a designation Oh, with the suit modification is pending, so I wonder if that's the appeal that's been referred to. Or changing the designation of the person who has the exclusive right to designate the primary residence of the child, or the effect of creating a geographic area, or changing or eliminating the geographic area within which a conservator must maintain the child's primary residence under the final order unless a temporary order is in the best interest of the child, and the order is necessary because the child's present circumstances would significantly impair the child's physical health or emotional development. Code 156.006B1, Texas Family Code West, quoted 2019. So, while there's a modification for pending or whatnot, nothing else, according to what this was just said, nothing else can be filed. A temporary order cannot be filed on top of a modification, if I understand this correctly. 106. And this is 12 pages, so I'm going to try to do my best to get through it. But this is important stuff. I mean, this is, again, I'm no legal expert, but just from what I'm reading, this does need to be paid attention to, because so far, Anne had no right to file that modification whatsoever under Texas Family Code. So, in her affidavit, petitioner states that their respondent father has refused to participate in family systems counseling with Dr. Linda Rollins Streets, and she claims that significantly impairs the children's emotional development because the children's father refuses to co-parent with her. No, you refuse to co-parent with him because you tried to register them for school behind their back. Also, because both boys, James and Jude, are in jujitsu and you couldn't sign James up as Luna, you kept them out of a lesson of jujitsu. So, no, it is you who refuse to co-parent. You want your way and no one else's. No, screw you. I'm sorry. I'm trying to... But, ooh. Anyway, I'm not as fired up as this one as I was the last one. Co-parent with her or town counseling. No, you want to counsel the boys separately. That's why there's 2 counselors instead of 1. See petitioner's affidavit, page 1, paragraph 1. The legal standard under 156.006B1 is known as the significant impairment standard, and it is a high burden for a movement under these circumstances and requires affirmative evidence of bad acts, which there's none, and nor Janicic have provided none, which let me also remind you what I said in that video about my hypothesis when it comes to Jessica Janicic. I think she's doing this solely for the money. I did mention reputation too, because she was the divorce lawyer for Judge Kim Cooks, and that actually did come up. If you guys don't remember, because I mentioned it in the last video, they tried to use that as a conflict of interest and tried to delay the trial last year of October. So yeah, that is a thing now. So honestly, I think Janicic is doing this for money. I don't think she gives 2 flying farts in space about Anne, about what Anne is pushing for. I think she's egging Anne on for all these motions because she gets paid either way. Scummy lawyer. Anyway, for a movement under these circumstances and requires affirmative evidence of bad acts, see Henry J.W. 2019 text. This, I guess, is quoting a case here. Text at Fort Worth 2019 original proceeding. See also in Reese Strickland 358 Southwest 3D 818 822 823 text at Fort Worth 2012 original proceeding. Not 100% sure what those are. You could Google those if you want. The access to the document is going to be in the Google Drive court doc folder 3. A person seeking temporary orders and modifications must provide evidence of bad acts, which is true, and has provided none that are more grave than alienating a child from a parent or a violation of a divorce decree. Sure. See in Real Strickland at 822-823. The statutory requirements mandate specific allegations as exactly how a child's emotional development would be significantly impaired. If anything, James and Jude have had to put on a happy face for mom. We've already mentioned in the last video, and I think some of the videos prior, is she has a winner child and a loser child. She wants to turn James into her daughter, Luna, which doesn't exist, by the way, and then she will mistreat Jude. So, I've said this, I'm not backing down from that, but yeah. I've gone over the call multiple times, FaceTime. Neither boy wants anything to do with Ann when they're at Jeff's house. Not because Jeff, mind you, and let me also point out that not because I didn't clarify this. When the boys have FaceTime with Ann, they are completely away from Jeff. They're completely away from Gwen. They're in their own room. Jeff does not have any control over the call, nothing like that. They go in their own separate room, and Jeff will either wait in another room or downstairs or something until the boys are done. So he doesn't loom over them. He doesn't control what they say. They act on their own. They want nothing to do with that woman while they're in Jeff's house. Okay. The statutory requirements mandate specific allegations exactly how. Already read that. And if anything, James and Jude are even more safe in Jeff's house, and they're actually able to be themselves because I know Anna claimed in her affidavit that James can only be himself when he's in Anne's home, which is total another bullshit. Okay. On page 2 of Petitioner's Affidavit, in paragraph 3A, there's a reference to an incident at a child's school's open house, which occurred in 2018, and is which totally irrelevant as it is predates the order that petitioner seeks to modify. That, I did not catch that in the last video. So pretty much what had happened at the open house is Jeff had brought, and it's been such a while, Jeff had brought boys' clothes for James, and brought James in a dress, and didn't want Jeff attending open house. Jeff came and recorded it. His friend George was with him, and it ended up being like kind of a spitfire, no physical violence or anything, and refused to hand over James like she was supposed to. The cops were called. It was dealt with, but it was a recorded incident. I did not catch that in the other video because I was on a time crunch, so I do apologize for that. But the other video is going to be linked at the end title. She then recites numerous things that she claims the children said or that the kids reported on the way home. See, the boys don't talk like that about Jeff, and Jeff does not talk to the boys like you claim. He does not tell them to shut up or I don't want to be with you anymore. No, never. And that the both kids said dad said, which is blatant hearsay and objectable, see page 2. So yeah, we went through all that garbage. Petitioner reverts to referring to her son as Luna, which, by the way, came out of a book, transgender book, about a boy who is trying to be a girl, and at night he's able to pretend to be a girl. We covered that, I think. What stream was that covered in? I want to say the one that goes over her mental illnesses, or possible mental illness, and we discovered where the name Luna even came from. So, yeah. Even though this court specifically found after the trial of the prior case in October 2019 that there was no court order changing the child's name to that. Yes, that was actually brought up. Dunlap brought that up, and I know O'Donnell brought that up. So there was no order changing James to Luna. Thank God. Okay, here we go. On her own, change the child's name to Luna on her own volition. Yeah, no, there is no legal documentation, and she's been trying to register James into any activity or school as Luna. See the court's memorandum ruling October 21st, 2018. Arguably, unilaterally, changing a child's name may significantly impair their emotional development. Yes, because she's put on this fake identity on James. She has forced it, and then she has her freaking kooky-ass friends enforcing the same garbage. Her friend, by the way, has managed to brainwash their little boy into thinking that he is a girl. Yes, she has a friend to where they have a full-blown trans child. I don't know if this boy is taking hormones. I really don't, but the dad is going along with it. So you can kind of tell who wears the pants in that family. Anyway, no, that's not a low blow. Because when I found that out, it's like, you're letting your wife destroy your son. Good job, buddy. Anyway, let's continue. What page am I even on? Oh, 3 out of 12. We got 9 more pages. I'm going to try to skim through some of this. On at least 2 occasions, her friends who are girls made sarcastic comments about these clothes. Such allegations fail entirely to meet the significant impairment legal standard. Yeah, that's because your kooky friends are in on this. And one of them actually brainwashed their little kid, like I just mentioned. The affidavit of petitioner is also objectable due to the fact that petitioner fails to state the basis of her knowledge, which is just hearsay. pretty much projection, whether it is based on her own personal knowledge or what someone else told her. And the majority of the statements contained in the affidavit are, by definition, conclusionary and not based on recitation of any actual events, but rather petitioners rank speculation about what might have happened had the counseling started in May, and which is in and of itself an independent and valid basis for this court to strike the affidavit in its entirety. See paragraph 5 on page 4 of the affidavit. This is kind of written how I write sometimes. Oh my. Finally, petitioner contends in her affidavit that the respondent father unilaterally withdrew the children from school and will homeschool the children. You're supposed to agree together, Anne, what school to enroll them in. And no, Jeff is not going to let you enroll James as Luna and embarrass the hell out of your kid again. No. Because the teachers were in on that shit too. So yes, legally the school had to unregister the boys because that is part of the joint conservatorship. And moving on. And she again states that his refusal to co-parent significantly impairs the children's emotional development. No, you do, because you tried to put the fake identity on James and then you abuse the shit out of Jude. Yes, that is not an allegation. The way that you treat that boy, I begin phone call. They don't want to talk to you. The way that you treat, you couldn't, let me remind my viewers, when this first started, it had come out that Jude needed occupational or cognitive classes. He wasn't stupid, he just needed some extra classes to help with his motor functions. No big deal. And kept putting off those classes. She does not care for Jude. She doesn't, honestly, from what I've seen, she doesn't care for either boy. She just wants her fake daughter, and she wants to turn her real son into her fake daughter. So, anyway, let's continue on. Again, she neglects to include any substantial facts that rise to the level required under the applicable legal standard, and she refers to behavior problems experienced by her, by her older children who are now adults, which is irrelevant, which, by the way, has to do with Blake Mitchell's evaluation, which, by the way, was tossed out, which, let me remind you, Al Britton tried to use, and guess what? That hearing, that October 2019 hearing, made him uncredible, especially seeing how he used the past evaluator's evaluation as his foundational piece for his own and played games for quite a few months. Let Anne do whatever she wanted because she was a pediatrician. No. So both Blake Mitchell and Al Britton are uncredible in the court when it comes to valuations. Anne's daughter and niece have nothing to do with this motion to modify. They're both, I'll leave it alone because those kids are going to constantly when they're older. Inadmissible in the current modification proceeding as to whether she is entitled to temporary orders changing the designation of which parent would have had the exclusive right to determine the minor children's primary residence. No, and I'm not shit-talking Zoe and Sydney. I actually had I didn't even recognize it at the time when I was doing one of my streams on this, one of my very first streams. Sydney came into my live chat and started screaming. The mods had booted her, but because I was looking at what's called chatbot versus a YouTube, chatbot still keeps the comment even though it's removed in the live chat. So I looked through the chatbot, it's like, who is screaming at me? And I recognized it later how it was Sydney. It's like, you need to keep your kids away from me. I don't want to talk to any of you. You got them corrupted and brainwashed to go along with this garbage. Zoe pushes this stuff at college. She's indoctrinated by the system. I don't want to talk to your kids. I don't even want to cross that line. So yeah. Standard or the burden on her as moving actual facts are required, and the facts that actually establish how a child's emotional development will be significantly impaired are required by the statute. So again, they cite a court case to truly establish significant impairment of a child's physical health or emotional development. The movement must present evidence of bad acts or omissions, which she doesn't have any. Okay, so this was... Oh, okay. So let me see if I missed anything. So we have the family code citing, which is awesome, which honestly should make Anne's motion to modify null and void which should throw out the temporary order filing, because if there is a motion to modify here, there's an appeal on record, so they should nullify everything from what I understand about an appeal. Again, I'm not a lawyer. I could be missing something. So do let me know. Let me see if there's anything else. We went through that. Like I said, I was trying to skim through this. Oh, illusions of bullying. We covered that. Yeah. Luna is already experiencing some bullying. You mean the bullshit you freaking started and how you shame him for wanting to be a boy, and then you shame his brother Jude for when he doesn't want to go along with your bullshit? That bullying? Also, let me remind you that occasional bullying in school does happen, but you can't even let James deal with actual bullying, normal bullying. I'm not condoning bullying. I'm saying it happens among young kids. He can't even cope with normal bullying because of this freaking bullshit. No, it just, what you were doing, they have to emotionally cripple themselves around you because freaking the alphabet soup forbid they be themselves. Ugh. Anyway, I think that is about everything. Let's go with the prayer. Whereof all premises duly considered, respondent Jeffrey Damien Younger prays that the court strike the affidavit in its entirety and for such other relief as the court may deem just and proper under the circumstances. So he's asking for relief because I know she keeps filing stuff. She filed a motion to modify. There's an amended. Now there's temporary order. So she has 3 things, which is pretty much a scattershot. So she's trying to see what sticks. And according to the Texas Family Code, by the way, let me show you it again. If a suit seeking to modify the designation of the person having the exclusive right, which, by the way, she is not sole, she is joint, to designate the primary residence of the child is filed not later than 1 year. Designate the primary residence of a child is filed not later than 1 year after the earlier of the date of the rendition in order or the date of the signing or mediated or collaborative law settlement agreement on which the order is based. The person filing the suit shall execute and attach an affidavit as provided by subsection B. So it's not even a year. Let's see, residence of a child is filed not later than 1 year. So it hasn't even been a full year yet. It's been 8 months. 8 months. That's it. And she's already tossed 3 motions at the court. Well, technically 1, an amended version, and then a temporary order. So motion to modify. So the woman is nuts. And Genesic is continuously to egg this on. But so don't forget, there's a hearing August 11th. I've been told it's at 1 o'clock. From what I understand, it is not a Zoom call this time. So last time there was a nasty Zoom bomber. Ew. I really hope they caught the guy because, ew. Custody case, come on, man. And it's supposed to be on a YouTube channel live stream. I will get that and I will put that up. Anyway, I will keep you guys posted as to what I hear. I will be at work August 11th. So I don't know if I'm going to be able to catch it or not. But I will definitely get back to you guys with an update. I'm going to try to sneak peek it just a little bit. As the last hearing was maybe an hour. So hopefully this one doesn't take that long. But anyway, I will see you guys in the next one. And if I hear of anything else, I will get back to you. You guys have a wonderful evening.